Alrighty, back. Um, these are We the People News. Educational purposes only. Alright? Never look straight forward, always look around you, be able to protect yourself by any means necessary. Look outside the box. Okay? Arm yourself with knowledge, people. And during my last video, talked about how people become monkeys. Well, you only become monkeys when you're imprisoned by one train of thought. You always got to keep your mind open. And by gosh, y'all, listen to me. Attorneys are hearsay. Judges are hearsay. Do your own research. Okay? I'm hearsay. Do not take anything for granted from me or this video. You are responsible for yourself. Alright? Attorneys are not responsible for you. Judges are not responsible for you. The cops are not responsible for you. And I am not responsible for you. Do your research. Alright, let's go.
For imposing taxes on us without our consent, for depriving us in many cases of the benefits of trial by jury, for taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our government. He's abdicated government here by declaring us out of his protection and waging war against us, and is found in the causes and necessities for taking up arms, 1775. Statutes have been passed extending the courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed and estimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law and instead thereof to publish and order the use and exercise of the law martial. Janet Yellen and her predecessors used the Vatican's fraud and deception of their minor estate entity, Glenn Whittingham Fern. Now I say that the heir, as long as he's a child, differeth nothing from a servant, though he be lord of it all. And that's Galatians 4:1. To use it as justification to assault and demand it with the Commerce Clause, Article 1, Section 8, Clause 3, in violation of Article 1, Section 8, Clause 17. To deceptively assault and demand it with a quasi-contract. And this is a subset in its origin, an action of tort. A subset was soon transformed into an action of contract, becoming afterwards a remedy where there is neither tort nor contract, based at first only upon an express promise. It was afterwards supported upon an implied promise and even upon a fictitious promise. Introduced as a special manifestation of the action on the case, it soon acquired the dignity of a distinct form of action which superseded debt. Now notice these words, these are commercial words that they're using. Which superseded debt, became concurrent with account, with case upon a bailment, a warranty, and bills of exchange, competed with equity in the case of essentially equitable quasi-contracts going out of the principle of unjust enrichment. Surely it would be hard to find a better illustration of the flexibility and power of self-development of common law. Yeah. See, there's a...
And I want to kind of stretch this out for y'all. All right. So I've used it myself, but due to further research, okay. Private property. You know, you call your house, your land, private property. But the way they use it by their definition, they're using it as the same as Walmart. Which, what is Walmart? Commercial. So private property is actually considered a commercial word by their definition. Now, was it ever always been that way? I don't know. But the founding fathers never said really private property as much as you have a right to own property. They never said private property. Okay? Or if they did, it was very few, and it was specific in a particular thing they was talking about. Okay, according to my research. Okay? Not y'all's. So, I guess the word, personal property could be used, but that scares me, right? So I just, maybe from this day forward, man's property, woman's property. We're going to just bypass all these trickery words and definitions that we fully do not comprehend due to their language that we do not comprehend. All right? And they're not even allowed to use it in this country because everything's supposed to be clearly understood by the average man. The good book says, woe to you attorneys. All right? Do I need to say any more than that? Religious people out there. Okay?
A lot of different types of common law. Anyways, both in Roman and English law, there were certain obligations which were not in truth contractual, but which the law treats as if they were. They were contractual in law, but not in fact, being the subject matter of a fictitious extension of the sphere of contract to cover obligations which do not in reality fall within it. Which requires the Vatican.
Yeah, right there. Presumptions. Right? Presumptions.
Minor estate / 31 CFR 363.6, U.S. citizen or other fiction. Constructive quasi-contracts are based solely upon the legal fiction or fiction of law. So the Vatican's bar members in the county of Montag can assault and demand it with their Texas tax code with their forced rendition, which is why the Vatican's fraud and deception of capitis diminutio. Capitis diminutio is the destruction or the kaput of legal personality. Capitis diminutio, so to speak, wipes out the former individual, puts a new one in his place. Between the old and the new law, there is, legally speaking, nothing in common. A juristic personality may be thus destroyed in one of three ways: by loss of status libertatis, this is capitis diminutio maxima, by loss of status civitatis, which is the capitis diminutio media, and by severance from the agnatic family, this entails capitis diminutio minima. And this is a textbook on the history and system of Roman law, Roman private law, and that.
Okay, and so for clarification, a couple of them things in there that he's talking about reverts back into of one like kind. Okay, dog is a dog, cat's a cat, man is a man. All right, a person is a person. Okay.
Black's Law Dictionary, 8th edition. Capitis diminutio maxima, meaning the maximum loss of status through the use of capitalization. That's all block capital letters. The highest and most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage, when he became a slave. It swept away all the rights of citizenship and all.
Yep. The 13th Amendment does not exist.
All family rights. That's Black's Law Dictionary, 4th edition. Because the Vatican's fraud and deception of capitis diminutio maxima is used when they enslave people, and they are Satanists using fraud and deception to sell people into slavery as collateral for their minor estate. He, the prisoner, has as a consequence of his crime not only forfeited his liberty, but all his personal rights except those of the law, those which the law and its humanity affords him. He is for the time being a slave of the state.
Okay, so furthermore, if you are a man or a woman, and if you cannot actually walk across the street without being punished by the state, you are in fact a slave, and you must have consent. So if you don't have that consent, right, you are a slave. So all these statute codes that people talk about violating, your rights and all that kind of stuff, they're violating because you are a slave. Every single law forces you into a slave. Argument's sake, in Texas, transportation codes is a crime. Not lawfully, legally, it's a crime. So anybody out there that's ever had a ticket is a slave until the day they die. Because they are never going to be unshackled due to every single time the officer types in the computer, it's going to show that it's an instrument. And that instrument is what a nexus is attached to the 13th Amendment, enslavement. So yeah, you're free. until you walk across the street. And if you got to pay property tax, well, you're not free. You're a slave. Sit and think about these things outside the box, y'all. And you can call me whatever name you want, but it doesn't change the fact that this may be true. All right? The original intent of taxes was income. The original definition, income, was corporations. All right? When the people passed it, and bad people at that time, passed it for the income, for the rich, for the corporation. When it got passed, the IRS, the revenue collectors and all that, changed the definition. So even the revenues definition is violation of the 16th Amendment of the tax code, or the tax amendment, because it was not the original intent of that time and era.
Which are non-judicial proceedings, because whenever a statute's involved, the Vatican's fake judge is actually a bought and paid for a clerk masquerading as a judge. When acting to enforce a statute and its subsequent amendments to the present date, the judge in municipal court is acting as an administrative officer and not in a judicial capacity. Courts administering and enforcing statutes do not act judicially, but merely ministerially, but merely act as an extension, as an agent for the involved agency, but only in a ministerial and not a discretionary capacity. It's the accepted rule not in the state courts, but in the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes, as a ministerial court for the agency. Judges become involved in enforcement of mere statutes, civil or criminal in nature, and otherwise act as mere clerks of the involved agency. I'm going to step aside. I'll be back in a minute.
All right, so right here we'll pause it because the video's at 13 minutes, and we're fixing to go to the Bill of Attainder. All right, and I believe here in Texas is Constitution 1. What is it? Articles, Section 16. It's ex post facto. All right, so a lot of these things, even the judge, the Supreme Court guy, died in Alpine, Texas, says 95% of the law is not law. If a Supreme Court justice says that, and you believe him on all this other crap, why didn't you guys believe him on that one? All right, this will be the People News. Bye, y'all.